Hello and hope all of you are safe. Welcome to the ninth lecture on the Introduction to International Investment Law. In the last two videos, we dealt with an important threshold issue in investor-state arbitration. What is an investment? In this video and possibly the next two, we will be dealing with another important threshold question: who is an investor? An investor should belong to the contracting party. This is important because of two interrelated aspects. The jurisdiction of the tribunal depends on whether the claimant belongs to a contracting party. Another important aspect is the substantive standards guaranteed in a treaty will apply to such parties. Before we address this issue head on, it would be useful to briefly touch upon the basis of evolution of international law regarding this question. Those who have watched the first five videos on the lecture series on international investment law would recollect that there were treaties made between colonial nations and the third world for the protection of nationals of the colonial nations. Thus, nationality of the colonial nation granted protection under those relevant treaties. Thereafter, the law on diplomatic protection evolved, especially through the decisions of the International Court of Justice, such as Nottebohm, that is Liechtenstein versus Guatemala, and Barcelona Traction. And the question raised in this video mostly evolved out of this law. Well, coming back to the question, who is an investor, is answered from the perspectives of the relevant BIT and from the ICSID convention when it applies. Like in the last two videos, we will take a look at the India UAE BIT of 2013 and the Brazil India BIT of 2020. Let us see what the India UAE BIT defines the term investor. It says investor means any national, company, or government of a contracting party. The definition looks fairly simple but contains a lot of concepts. Firstly, it is an exhaustive definition. Second, it covers a national, which is a reference to natural persons. It also covers a company. And interestingly, it also covers a government of a contracting party. Now, what is amiss here is, for example, what would happen in the case of, say, a partnership firm who is an investor, or or a or a business entity that is not a company, for example, a limited liability partnership. So there is no clarity in this definition. But let's see what the Brazil India BIT says. Brazil India BIT defines the term investor to mean any natural person of a party that makes an investment in the territory of the other party, or any enterprise constituted and organized in accordance with the law of a party other than a branch that has substantial business activities in the territory of that party and makes an investment in the territory of the other party. This is a relatively comprehensive definition of the term investment. It is an exhaustive definition covering both natural persons and enterprises. The term enterprise is also defined to mean any legal entity constituted, organized, and operated in compliance of the law of a party, including any company, corporation, limited liability partnership, or joint venture, and a branch of such entity established in the territory of a party in accordance with its law and carrying out business activities there. Nothing in this treaty shall be construed to require any party to authorize the provision of financial services by branches. Thus, we see that this is a very comprehensive definition, and it also addresses those gaps that we pointed out some time back as regards legal entities other than companies. It is also interesting to note that this definition does not cover the government of a contracting party. More on the question who is an investor in the next few videos. Take care and stay safe. Bye bye.